always seeking justice and truth. This ducky won't be silenced by the haters, seeking out the facts while providing the receipts. She is loud with her opinions in this cruel world of villains. This ducky will talk, give her sass, while still keeping her class. So join in the pond with the ducklings from all over the place.
Welcome, y'all, to the Loud Little Ducky. We are going to go over the Aaron Spencer case. There is a lot of updates that have happened in this case as we were gearing up to start jury selection on the 26th. That now has since changed. Aaron Spencer's lawyers wanted to recuse Judge Barbara Elmore and have the public trial more public than Elmore was allowing. She was also wanting to get real big with security, which confused the defense a bit. So we're going to go into all of that and see what we have. Now, if you are not familiar with Aaron Spencer is a father who lives in Lonoke County, Arkansas. His daughter was a victim of a 67, 64-year-old predator named Michael Fossler, his daughter being 13 at the time of the incident. Now, Aaron Spencer woke up around 1 a.m. in the morning to find that his daughter was missing because his dog started barking. And so Aaron went to go look for his daughter, his wife at home, calling 911. And Aaron Spencer runs across his daughter in the predator's vehicle. Now, the predator was out on bail for 43 different charges in regards to Aaron Spencer's 13-year-old daughter. He only had to post $5,000, and Aaron Spencer tried to get Michael Fossler to pull over and hand his daughter back over. In my opinion, this is him kidnapping her. I don't care how she ended up in the vehicle. Michael Fossler was told to stay away as a part of his bail conditions, which he did for 3 months, supposedly. I don't know if he just didn't text her for that long, but as far as we know, there was at least no physical contact up until this date in October. And so Michael Fossler did not relinquish Aaron Spencer's daughter. He got out of the vehicle. Aaron Spencer then shot him 16 times, 15 of those hitting Michael Fossler, and Michael Fossler dying. Some call him a hero, but the state wants to portray this case as a vigilante case. And the thing is it would be a different case if Aaron Spencer, as soon as Fossler got out on bail, went to Fossler's house, knocked on his door, and then shot him then. That is not what happened. Michael Fossler was in the act of kidnapping and committing further crimes against Aaron Spencer's daughter, who is the only witness to be able to testify against Michael Fossler and put him away for probably the rest of his life, since he's so old. And Aaron Spencer says it is self-defense because his daughter and him in that moment were in imminent danger. We don't know if Fossler was going to rid of Aaron Spencer's daughter so that she couldn't testify against him at his criminal trials that were coming up, or commit further SA acts on her. So It has been a very controversial trial. There was a gag order originally placed in this case by Judge Elmore, and the Supreme Court of Arkansas came back and said, absolutely not. We are not gagging this case. This should be a last means. Things should be public. We do not do trials in secrecy. Even one of the justices in the Arkansas Supreme Court stated he thought Elmore should be recused back then. Now, here we are, days before jury selection is supposed to begin in this case, and the defense has motioned for a recusal from this judge. She does not want to, and so they did a writ of certiorari to the Arkansas Supreme Court. So we're going to look at first what they kind of submitted to the state court. Because remember, when you're asking for a judge to recuse themselves, you are asking the judge that you want removed off the case to remove themselves. You're not asking somebody else. And so usually they're like, yeah, no, I'm not biased. I'm not getting off this case. Ethical judges and people remove themselves without having to be asked if there's problems. But she states there's no issues and she's not biased. But if you have followed any of the rulings in this case, it just doesn't line up. One of the rulings that Judge Elmore had recently made, and they even asked her to reconsider, was about needing a expert to come in and explain how the grooming process works. And the grooming and the essay and all this stuff about predatory behavior and how it affects people and all that, because, which is very important to understand, because the state wants to say, which infuriates me, that, well, she got into the vehicle willingly. I don't give a fuck if she got into that vehicle willingly. She's a minor. She does not have permission to be in that vehicle. And Fossler had permission from nobody to take her. So I don't care how she got into it. The fact that she's even willing to, everything that was done to get her to that point where she didn't say no or couldn't say no, or maybe thought she might have feelings or this person cares about her, there is a psychology behind it. And while a lot of people that are on, the interwebs and follow true crime and know about all this stuff, understand the grooming psychology and what's behind it, and it is not the fault of the child. But there may be some people that when they hear the word grooming, they think of shaving and getting a haircut, primping, in the mirror and stuff like that, when that's not what it is. And so the defense wants this jury to understand what grooming is and what effects it can have on a child, and get them to get in that mindset when they are looking at why Aaron Spencer could have had in his mind that his daughter was in imminent danger, and not blaming it on Aaron Spencer's daughter, who to me is the ultimate victim in all of this. But the state just cares about Michael Foster being the victim. They don't consider Aaron Spencer's daughter a victim in any of this, by the way that they argue things, which is very infuriating, as anybody with human decency. So let's go ahead and pull up this argument. Let me see which one is. Okay. So we are going to pull up this one. Okay. All right. So here we have in Aaron Spencer's case, filed on January 16th, the defendant's brief in support of motion for judicial recusal. Defendant Aaron Spencer asks Your Honor to recuse himself as presiding judge in this case, while Spencer still holds the unshaken belief that the court remains a place where justice is sought, not defended. The court's comment and conduct have cast doubt on the constitutional guarantee of a neutral and open tribunal. From the outside of this case, Spencer, his counsel, his family, and publicly criticized the actions of Lonoke County officials, including the prosecuting attorney, law enforcement, and the court. The court's decision to release Fossler on bond, the propriety of charging Spencer for actions taken in defense of himself and his child, and the integrity of local law enforcement, given its failure to preserve critical evidence. As proceedings unfold under increasingly public scrutiny, the court has repeatedly restricted public access, constrained defense advocacy, impeded transparency, and responded defensively to oversight. Viewed cumulatively, this pattern gives rise to a reasonable perception that this court is aligned against the defense and is seeking to shield its prior conduct from public examination. The court's conduct undermines the appearance of impartiality. That Rule 2.11a of the Arkansas Code of Judicial Conduct is designed to protect, which requires recusal. And then it goes through the table of contents. Legal standard. The Arkansas Code of Judicial Conduct provides that a judge shall disqualify herself in any proceeding in which judge impartiality might reasonably be questioned. This duty is mandatory. Ramirez versus White County Circuit Court from 2001. Arkansas courts have emphasized that the analysis must be undertaken from the perspective of litigant and the public, not the subject intent of the judge. Ferguson v. State, a 2016 case. A trial judge has presumed impartially, and the party seeking recusal bears the burden demonstrating otherwise. But where conduct goes beyond conclusory allegations and raises a reasonable question of impartiality, a hearing is required. Rule 1.2 requires that a judge shall act at all times in the manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary and shall avoid impropriety and the appearance of impropriety. Comment 5 explains the test for appearance of impropriety is whether the conduct would create a reasonable mind's a perception that the judge violated the code or engaged in conduct that reflects adversarially on the judge's honesty, impartiality, temperament, or fitness to serve. Arkansas Supreme Court has explained that shall is a mandatory rather than a discretionary. Comment 1 further provides that a judge is disqualified whenever a judge's impartiality might reasonably be questioned, regardless of whether any specific provisions applies. As the Arkansas Supreme Court has stated, if a judge's impartiality may reasonably be questioned, Rule 2.11a is invoked and disqualification is required. And Arkansas case law requires a circuit court to remain mindful of the perception of bias from the litigant's perspective. Ferguson v. State. Rule 2.3 prohibits a judge from manifesting bias or prejudice by words or conduct and requires the judge not to permit court staff or other subjects to judges' control to do so. The comments recognize that even facial expressions and body language can convey an appearance of bias or prejudice, and a judge must avoid conduct that may reasonably be perceived as prejudiced or biased. To me, that reminds me of Judge Canoni and all her body language bullshit, her sighing, rolling eyes, eager to object for prosecution, all of that stuff. Rule 2.8 similarly requires a judge to be patient, dignified, and courteous to litigants, witnesses, lawyers, and others. And then it goes into the background that we've gone over, lured from the middle of the night, sexual exploitation, including SA, internet stalking, and CP. And this all happened October 8th of 2024. Spencer discovered his daughter was missing, and Foster fled with the child. Spencer feared not only renewed abuse, but Foster would eliminate the sole witness standing between him and a life sentence. To prevent further harm to his child, Mr. Spencer forced Fossler's truck to stop. Fossler exited the vehicle and continued to pose an imminent threat to Mr. Spencer and his daughter. Mr. Spencer killed Fossler to protect himself and his child. And as Defense Diaries always asks, how far would you go to protect your child? And so next they go into reasons why recusal is required. The court has exhibited both apparent and actual bias against Spencer and his legal team, such that the court's impartiality is reasonably in question. Spencer does not make this motion without serious consideration of the issues herein. However, given the seriousness of the proceeding and the unusual circumstances involved, defense counsel must make all efforts to safeguard Spencer's constitutional rights to due process and fair trial before an impartial tribunal. Number 1, early proceeding restricting public access and defense advocacy. At Spencer's arraignment in November of 2024, the court closed the courtroom to the public in violation of Spencer's constitutional right to a public trial and the corresponding right of the public to attend the trial. When the defense counsel objected, the court refused to hear argument and directed counsel to file a motion and brief, despite the fact that the proceeding would conclude before any relief could be obtained. This immediate restriction on public access, coupled with refusal to hear a contemporaneous objection, set the tone for subsequent proceedings. Yeah, she don't want to hear you. She does not give a shit what anybody has to say. She is going to do whatever she wants to do. 2 days later, the state sought an overbroad gag order that prevented nearly all speech about the case other than the state's allegation. The court limited defense counsel's response time to 5 calendar days beginning Thursday, December 5th, 2024. Spencer filed a timely response that included a request for a hearing. Within 6 minutes of the circuit court clerk docketing Spencer's 19-page response, the court granted the gag order, denied a hearing, and added handwritten provisions broader than those proposed by the state. The court added references to the defendant and his family and sealed the entire case from public view. The Arkansas Supreme Court intervention and expressed concerns about this court. So this is what I was talking about. The Arkansas Supreme Court granted a different writ of certiorari. Now I'm looking at the word and I can't say it. And vacated the gag order on May 29, 2025. We have done a video on that and the hearing, and I will put those in the description box below, or they are in the playlist for Answer Aaron Spencer that we have on the channel. separately to concur and express concern about Circuit Court's repeated efforts to shield proceedings from public view, including closure of arraignment, sealing of the case, and timing and the breadth of the gag order. She did not read a 19-page document and write her own response in 6 minutes. It didn't happen. She wrote the response way before any of this. She does not give a shit what the defense had to say. And the Arkansas Supreme Court said, well, you're going to give a shit about what the defense has to say. Those justices explicitly raised concern that the gag order functioned to suppress public criticism of the state and the circuit court for setting Fossler's bond low, thus facilitating this release and setting in motion the chain of events leading to the confrontation at issue. They suggested that this matter should be assigned to a new circuit court judge because anything less suggests that what happened so far is within the acceptable range of disagreement or administration, and it isn't. This intervention weighs heavily in accessing whether a reasonable person could question the court's impartiality. Yep, they thought that at least one of them thought this judge needed to go back then. Resistance to disclosure of public records related to Fossler's bond. During that same period, defense counsel attempted to verify information reported about Michael Fossler's bond, a proceeding that from all available records traces back to the circuit court. The district court confirmed it had no record of any appearance by Fossler. Exhibit A, which we will get to those. The circuit clerk produced the information and a one-line docket sheet, but no bond order, Exhibit B. The court reporter confirmed that no verbatim record of Fossler's bond proceeding was made, and no waiver of such record appears in the court's file, Exhibit C. So where the hell are these records? This is suspicious. Arkansas law mandates that a complete record be made of all circuit court proceedings unless waived by the parties. Yet, despite repeated requests for what should have been a public and complete record of the court's business, no such record was located. Did they have it and then it just got destroyed? Like, where is this and why is it not there? Has it always just not been there? Or did it once and it's just mysteriously disappeared so that Aaron Spencer can't use it? Both before and after the gag order, Spencer and his representatives have been publicly critical of Lonoke County officials, including the prosecuting attorney, law enforcement, and the circuit court, Exhibit J, from November 27th, 2024 and May 29th, 2025. That criticism focused in part on the circuit court's handling of Fossler's release on unreasonable low bond with no meaningful restrictions or supervision, and on the prosecutor's decision to charge Spencer under those circumstances. The issue of who set Fossler's bond was raised in Spencer's opposition to the gag order motion, discussed in multiple briefs, and discussed before the appellate court. Throughout that entire period, neither the state nor the court ever suggested that anyone other than this court had set Fossler's bond. The silence is significant. And keep in mind, they're saying this court. They did not say Judge Elmore specifically right now. On May 29, 2025, the Arkansas Supreme Court granted Spencer's writ of certiorari and vacated the gag order. Only after the Supreme Court's rebuke on June 5th, 2025, did the state, for the first time, email defense counsel a document purporting to show that Your Honor had not personally signed Fossler's bond order. Well, that's amazing. And it says Exhibit D. That document had never been produced in discovery with the rest of Fossler's case materials, was not provided by the circuit clerk, despite prior request, and appears nowhere on any docket through case search. It is barely legible, lacks a case number, lacks a file mark, and bears the title of circuit court order, even though it purports to be signed by a district judge. The sudden emergence of this unidentified, unfiled document after months of silence and only following the Supreme Court's criticism raises serious question about transparency, record of integrity, and possible attempts to retroactively obscure the process that led to Fossler's release on bond. So that answers some of that question, because I have read some of this stuff before now. I haven't read everything, but they were saying Judge Elmore didn't do this. It wasn't Judge Elmore that set the bond, because the narrative out there before was that it was the same judge who apparently set that bond and let Fossler out. And now the same judge was wanting to keep things secret because she's embarrassed that she let this predator out. And so whether it was Elmore or somebody else in that circuit court, somebody did. And they tried for months and months and months to find out information about Fossler's case, who set the bond, who saw him, everything. And nobody could produce anything. And then all of a sudden, the Supreme Court, knocks them on their ass, and they're like, oh yeah, here's this thing. Like, it was written in Crayola from a kindergartner, but yeah, this goes to Fossler's case. See, Judge Elmore didn't do anything with this case. So, you can't, and you have to be able to verify the validity of these documents. Where did they come from? Who created them? Where were they recorded? Like, you can't just pull shit out of your ass, because things have to be authenticated. And it just seems like, no, we're just going to make things up. And I hate retroactive things. I don't like when it's a retroactive report. I don't like it when it's a retroactive chain of custody, because why aren't you doing your job to begin with? This is not how we do things. So it says whether the court personally signed the order or directed another judge sitting in the circuit court to do so, the bond was issued through this court. And this court subsequently presided over Fossler's criminal case, which that is true. The circuit court did. The case charged 43 offenses, so it's 40, including additional felony counts of a different nature not known at the time of the arrest. Despite new and serious allegations, the court never revisited or modified the bond conditions. Instead, this court allowed Fossler to waive arraignment, set pretrial and trial dates, seal the affidavits supporting the arrest warrant, withheld the felony information from public access, entered final judgment after Fossler's death, and sealed his death certificate. Yeah, they have sealed things on Fossler. You can't really get much from his case when you look it up. And I'm sorry, if you die, your documents should still be public. That's just my opinion. A year later, when defense counsel again sought a certified copy of the order granting bond, the same resistance appeared. When counsel staff called to request the documents, the clerk advised that the court had to give permission before releasing public records, even though it did not contain any confidential information and was not under seal, Exhibit E. After weeks with no response, written request followed. The clerk eventually claimed her office had no bond order, Exhibit F. After several more emails and a specific request for an explanation, the clerk produced a bail bondsman form. The defense counsel asked for a written statement acknowledging the absence of a court order for Foster's bond. 2 weeks after the first request, the clerk finally produced a pretrial order, quote unquote, ordering the bond. The bond order provided by the clerk, however, does not match the document sent by the state several months prior. It is already altered to contain a case number, although the case number does not return to any open case on case search and is not the number of Foster's criminal case. So, what is this number? Like, what is this bullshit? The bond order thus remains inaccessible to the public. And then they said Arkansas Supreme Court Admin Order Number 2 requiring properly labeled docket bookings or books, including SW and AW, for warrant dockets, detailing what is properly filed in warrant dockets, and requiring transfer of such filings to the corresponding criminal case. The only constant in these irregularities is the assigned court and the control over the record. Yeah, it's still the circuit court. The pattern of withholding and gatekeeping of public records extend beyond a single instance. In December 2024 and January 2025, after 3 weeks of follow-ups by phone and email, the circuit clerk, acting under the court's supervision, produced only 2 documents in response to requests for the entire case file, then ignored follow-up inquiries, Exhibit B. On multiple occasions, the clerk told the defense counsel staff and others that she needed the court's permission to provide documents, including in situations where no sealing order or cause for sealing existed, Exhibit E. This was also the circumstance when counsel requested both sealed and unsealed certified documents, Exhibit G. According to the clerk's comments to counsel staff, the court also appears to determine which filings are visible on the public case search system. For example, the charging information in Foster case remains unavailable online despite no reference to any specific minor. The pattern continues even this week, Exhibit H. Redacted email from a member of the public seeking amended information filed in the Spencer case. Yep, you cannot find it online. And I believe I've showed you that in other videos. The pattern suggests concealment and control over the public knows about proceedings handled in the courtroom. The cumulative result is a system in which access to public records depends on judge personal discretion, contrary to law, to transparency, and to the principle of open courts. 4. Orders and rulings that burden the defense and reflect retaliatory control. This court has repeatedly exercised its administrative authority in ways that hinder defense's preparation, distorts parity between the parties, and reinforce the perception that the court is personally invested in the outcome of this case. The resulting pattern, arbitrary scheduling, asymmetric burdens, and punitive rulings suggest not neutral case management, but deliberate hindrance of the defense's ability to prepare. Without prior discussions or necessity, the court entered a scheduling order that imposed compressed and impractical deadlines. The discovery deadlines was 30 days after the entry of the order, with all motions due 2 days later on a Saturday, and responses due on a date certain 10 days later. On the following Monday, the court issued an informal email ordering all motions filed that day. Responses were then due 8 days later. At that point, the state was consistently providing voluminous discovery materials to the defense. These overlapping and unrealistic dates left the defense with inadequate time to review discovery, investigate, and raise constitutional and evidentiary issues. Yeah, it was just a huge dump. And it was bam, 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 bam. And so, like, Aaron Spencer has a couple of lawyers, and the prosecutor's office has anybody and everybody. Yeah, there's going to be one person like writing the motions mainly, but defenses don't always have that. Sometimes there's only one defense attorney. And so if this was a case with one defense attorney, then like this would be almost impossible. You could put out things, but sure, you can read things, but really to absorb and then look up cases to back your arguments and find sightings and review other things can take a while, especially when there's huge dumps, which, state, sometimes likes to do. They like to be like, well, here is 30 boxes. Each box has like 500,000 pages in each box. And so, good luck finding what you're looking for. Because they're like, well, we disclosed everything. Not our fault they didn't find the needle in the haystack in all these boxes. Okay. When the parties jointly requested a realistic extension and schedule and advised of ongoing discovery disclosures that would inform counsel's motion practice, the court granted only partial relief, setting deadlines for the motions the Monday before Thanksgiving, with responses due the Tuesday immediately after the holiday week. Particularly, in light of the state's ongoing discovery disclosures at the time, the resulting schedule effectively eliminated usable preparation time and forced defense counsel to choose between compliance and completeness. Shortly before the motion's deadline, this court entered yet another unusual directive. All motions and replies most often in these cases filed a single-page pleading. Example, motion with an accompanying brief were to be accompanied by separate briefs, and motions filed in the prior month and a half were to be refiled with an attached brief. At that point, only the defense had filed detailed substantive motion and reply, while state had filed one motion containing 6 general sentences, as it typical in criminal cases due to the need to address potential constitutional violations and adequately preserve issues for appeal. The defense filed the bulk of the motions involving substantive issues and legal analysis. The new requirement imposed a greater administrative burden on Spencer's counsel, forcing duplication of work and diverting limited resources from substantive preparation. Which, if you've seen any of us covering these documents, there is the motion and then there is the brief. And a lot of it's the same information. One usually does have a little bit more than the other. But, like, why is one not enough? Why can't you just have it as this and this? But okay. The court's later rulings reinforce the interference of retaliation for Spencer's successful challenge to the gag order. On the motion's deadline, the defense filed a narrowly tailored motion to file certain pleadings involving Spencer's minor daughter, the victim and Fossler's underlying offenses under seal. The motion explained that those filings contained sensitive personal communications with third parties unrelated to the issues in this case and sought to file them under seal to protect the child's privacy and emotional well-being. The state filed no opposition. The court denied the motion, outright stating, the court will not at this time have any court documents filed under seal, and permitting only the use of minor initials in this case. However, the minor's identity is readily ascertainable from context, and the use of initials offers no protection. The refusal to seal even the most sensitive material where no party objected and where sealing is routinely granted in comparable circumstances cannot be explained as neutral application of the law. It reads instead as a punitive, a message that any party who challenges this court's authority, as Spencer did when appealing a gag order, will face maximum procedural resistance. The court's refusal to appropriately consider the request under the circumstances had the obvious effect of hindering Spencer's ability to seek review of evidentiary issues and make a thorough record of doing so without effectively harming his own child. It certainly gives the appearance that the court is prejudiced against Spencer for his efforts at overturning the gag order. So that was another one that I saw where they were like, well, the defense tried to file something under seal, and I didn't allow it to be sealed because they want everything so public. Then here you go. It's like, so because your panties are all in a wad, because you got reprimanded by Arkansas Supreme Court, you're like, fuck protecting children. He wanted everything public. Everything's going to be public. But it's just, it's nasty. There's no reason for it. Because you're so mad. You want to hurt a child. She gives no shits about how much shit that this child has been through because of this court and Michael Fossler. And just is insane to me. Like, how are you going to act like this as a grown-ass woman? By imposing rigid, unrealistic deadlines, demanding duplicate filings, and refusing basic protective measures for a child victim, this court has created the appearance that the rulings are driven not by efficiency or law, by animus towards the defense. Each of these acts, viewed together, exemplifies why this court, continuing to preside over this trial, undermines the confidence in the impartiality of the judiciary. Conduct at the December 25th pretrial hearing. Let me get a drink real quick before we continue. All right. The December 2025 pretrial hearing demonstrated the conduct inconsistent with judicial neutrality. Through the rulings and the courtroom management, this court fostered hostility toward the defense, amplified public perception of Spencer as dangerous, and imposed conditions that discouraged public attendance and hindered effective defense advocacy. Now they're going to get into the excessive security and public intimidation. Before the hearing, this court, sua sponte, meaning on their own, nobody asked for this. The judge just decided to do it because she wanted to. Entered an order removing Lonoke County Sheriff's Office from courtroom security and declaring the court would make alternative security arrangements. What followed was a show of force unprecedented for pretrial proceeding, particularly with a defendant not in custody and without any prior demonstration of the propensity to escape or engage in the courtroom displays of violence. Officers from the last 5 law enforcement agencies saturated the courthouse inside and out. At least 4, sometimes 6, Arkansas State Police officers remained stationary around the courtroom at all times, one positioned directly beside Spencer. Additionally, officers occupied the hallways, stairwells, elevators, and entrances. Just one second. I'm going to text her. Okay. Since I'm recording. Okay. At least 4, sometimes 6, Arkansas State Police officers remained stationed around the courtroom at all times, one positioned directly beside Spencer. Additional officers occupied the hallways, stairwells, elevators, and all entrances. Police vehicles ringed the building, established by another perimeter some distance away. Drones patrolled overhead. Officers escorted Spencer to and from the courtroom. Public attendees were not permitted to bring electronic devices in the courthouse, and all bags were searched prior to entry. The parking lot around the courthouse were closed and empty other than police units guarding them from the outside. The courthouse appeared closed to the public. That's insane. They don't even do this for the worst of the worst. Like, this is not a good look. This makes it look like Aaron Spencer is so dangerous that you cannot even be in the parking lot of the building of the that this man is in, because he is such a danger. But he's out on bond. Okay. Like, it'd be one thing escorting him to and from the courtroom and just being around him if they were in custody. But Aaron Spencer is not in custody currently. Like, they don't even do this nonsense for Taylor Business, who has attacked her attorney in court several times, who spits on people and has to wear a mask, who is chained, and everything else because she is out of control and dangerous. But they want to do all this for Aaron Spencer? Like, I don't see them doing this for every other defendant that's in that courtroom. They go on to say the excessive display discouraged the public from attending and conveying the message that Spencer posed a unique threat, an image woefully unsupported by any incident or risk assessment. These measures were unnecessary and unmistakably theatrical, reinforcing the perception that this court intended to portray Spencer as dangerous and to discourage the public scrutiny of the proceedings. Derision towards the defense and arbitrary admonitions. Once the proceedings began, the court's demeanor towards defense counsel was openly dismissive. The court expressed irritation about late stuff, quote unquote, even though defense counsel has not missed deadlines, and launched into a rebuke. Oh, Lord. The judge is going to rebuke them in the name of Jesus? Woo! Okay. No more trying to get around doing a reply brief by doing a second amended, third amended, because the law hasn't changed since then. I know what was going on, and that's fine. You figured out a way. But the law did not change from one time when Mr. Kaiser wrote it and then Miss Casanelli wrote it, or when the prosecution, when theirs wrote it, and then the next one. There was no change in the law. There might have been a change in what you stated, but there was no change in the law. Okay, thank you. This was from pretrial. Although the remark nominally referenced the prosecution in person, it was plainly directed at the defense, naming Spencer's attorney. Counsel had filed no amended pleadings, leaving the purpose of this admonition unclear. What is clear is the tone, contemptuous and accusatory, unsupported by the record, and calculated to diminish counsel in open court. Moments later, the court interrupted defense counsel's argument with, "Let me stop you right there. I enjoy the theatrics as much as anyone else. Such commentary on theatrics suggests that the defense advocacy was mere performance rather than legitimate argument, undermining counsel's credibility before all present." Ugh. Shut up. Shut up, Judge Elmore. Suppression of relevant evidence and protection of Vossler's image. The court repeatedly interrupted counsel when discussing evidence of Vossler's abuse and its relevance to the case. The following exchange captures both the court's hostility and its refusal to permit the defense to present a full narrative. So here we have Miss Casanelli. "Well, Your Honor, the state hasn't presented evidence yet. Yet expert testimony is admissible when it assists the jury in understanding the evidence. And the evidence is going to be in large part about Michael Vossler having abused this minor." The court says, "Wait a minute. Ms. Casanelli, having been charged with it," the court, "Wait a minute. We are not having a trial on Michael Vossler in this case. Do you understand? Michael Vossler never had a trial, okay? So we're not going there." Ms. Casanelli says, "So," the court says, "and we're not going to go there today in this." Ms. Casanelli says, "So the jury's not going to know that Michael Vossler abused this minor, was arrested, charged, released on bond, and then came back and picked her up during the night?" The court, "I expect some of that to be done, but I also expect the jury is smart enough to figure out things without your expert telling them what to do or what to think about the situation. I think you're only trying to confuse them and bring in things that they do not need to hear any more of." This is his whole defense. Aaron Spencer's whole defense is what a nasty pervert this man is. And what he did to this child, the fact that he was charged, then he was let out on bond, and it still did not deter Vossler. Getting arrested and having 43 charges did not deter Vossler from continuing his criminal acts against Aaron Spencer's daughter. But yeah, we don't need to let the jury know about any of that. They will just be smart enough to figure all that out. And having an expert come in here and tell them these things is just going to confuse them. What? You are allowed to present a defense. And I'm sorry if having an expert there to talk about these things or bringing up Fossler's past is not good for the state. And that they can't combat this. Well, you shouldn't have brought the damn case to begin with. This is so infuriating. Yeah, we're not going to tell, we just are not going to tell things about Fossler and let them know that he was a predator. Get the fuck out of here with this shit. Ms. Casanelli says, well, if state's position is that the minor was not abused, was not groomed, was not manipulated, court, I don't know. Wait a minute, Ms. Casanelli, that the court, I don't know what the state's position is on all that. I know what you say. I have read it, reread it in your motions, but I am telling you today that my jurors will be smart enough with the evidence presented and not this expert witness that you intend to call. And that's the ruling of this court. If you want to file something, I've already told you to do it, but it's it on this one. Okay. Yeah. She seems so great to try to bring things up to try to defend your client zealously. They are zealously trying to advocate for their client. And the judge is like, yeah, absolutely not. There's going to be no defending people. The state gets to just do whatever they want, and you just have to take it. By cutting off this line of argument and refusing even to allow contextual discussion of Fossler's conduct, the court effectively shielded Fossler's actions. The precipitating events of this entire case from the fact finder's understanding, the court's insistence that we are not having a trial on Michael Fossler, ignored that Spencer's defense necessarily turns on what Fossler did and why Spencer reacted the way he did. Yeah, it wasn't an uncle that came and picked her up. It wasn't just a friendly neighbor who's done nothing to her. It's not a random boy from school that Spencer didn't know anything about and just decided to do this. And any man that would have been in the car with Spencer, he would have done this. That is not what this is about. Why would Aaron Spencer feel like his daughter and him are in danger? Because Fossler is a predator and has essayed his daughter. Mind-blowing. Fossler's conduct is integral and critical to an assessment of Spencer's action. Integral and critical. This restriction reflects not judicial efficiency, but suggests an effort to protect Fossler and the court's prior handling of Fossler's case from scrutiny. Favoritism towards the state and disregard for fair process. The court again departed from neutrality when the prosecution belated produced substantial discovery and notice of an expert and his report. The defense notified the court that the critical data that had been produced on the Friday before the Monday filing deadline, that an updated expert report arrived the afternoon before the hearing. The expert himself admitted he had planned to gather additional data and again revise his opinions, despite the defense's request for time to review this late evidence. If not excluded, the court ordered the hearing to proceed and instructed counsel simply to listen. This refusal to grant even minimal accommodations rewarded the state's noncompliance and deprived the defense of meaningful opportunity to prepare. Further evidence of bias in administration of the docket. unresolved pro hoc vice motion and punitive delay. To ensure effective examination of the state's cell tower expert, defense counsel requested a ruling on a pending motion for pro hoc vice admission of an attorney awaiting Arkansas licensure after leaving federal practice. The attorney is more familiar with the expert's highly technical subject matter and would have been more effective in cross-examination, and the state did not object. The court stated that it already ruled on that yesterday, but in fact, it had only emailed that it would not decide the motion before the hearing. See Exhibit I. The court refused to rule, and the attorney did not participate in the hearing. There was no conceivable prejudice to the state and no logical reason for the court to refuse to grant pro hoc vice status to an experienced attorney prepared to conduct the cross-examination, particularly when the state had only recently disclosed the materials. The only effect was to prevent the defense from using its most qualified attorney in that specialized area at the critical juncture. This court still has not ruled on the motion. The continuing and the unexplained delay has left the defense unable to allocate trial responsibilities or prepare fully, further undermining confidence in the court's impartial administration of this case. Baseless accusation of defense counsel of malfeasance. The pretrial hearing culminated in the public accusation of misconduct against members of the defense team. The attorney was seated with the other staff on the bench reserved for the defense team directly behind counsel's table over the railing. While a lengthy video exhibiting was playing, the attorney used her phone to research an evidentiary issue at lead counsel's request when she was abruptly singled out and publicly sanctioned. The court stopped the video, pointed, and shouted, "Ma'am, you're out. You go outside the courtroom right now, and you stay out the rest of the day now." When the lead defense counsel explained that the ejected individual was an attorney assisting the defense team, the court responded, "I don't care. There are no phones during this recording and stuff going on. She can exit the courtroom. If I see anybody else with a phone while this stuff is going on, they will exit the courtroom." There had been no prior instruction restricting phone use by counsel. The phone the attorney was using was in silent mode and in no way interfered with the proceeding. Roughly 30 minutes later, the court again abruptly stopped the video exhibit and escalated the incident further. All cell phones are out of this courtroom. There's somebody texting what's happening in this courtroom, and they're talking about jurors and everything else. If it's not, I'll have each one of you searched for a cell phone. Everybody leave your cell phone outside this courtroom now. The court elaborated. Somebody's texting what's happening in this courtroom. I don't know if it's the lady I got rid of a while ago or what. It's a text. Okay. Then this exchange happened. The court. You can put it in a bag as long as it's not on. Turn it all off. I want to know if that lady was sending out stuff, if that was the one. Miss Casanelli, I'm sure it wasn't. I'm 100% certain it wasn't. She's a lawyer at my office, and she was probably texting us information about, she's doing legal research for us and texting us what she finds. The court, well, Miss Casanelli says she absolutely would not do that. The court, this has to do with 4 jurors and everything else. Only anybody that came in here after lunch knew about that. When defense counsel sought clarification, the court claimed that someone had posted about the hearing on social media, implied that the dismissed attorney was responsible. Okay, who gives a fuck? Why is this not a public courtroom? The court was mistaken in asserting that only someone present after lunch would know about the voir dire procedures. They had also been discussed earlier that morning. No actual jurors were identified, only that 4 potential jurors would be questioned individually during voir dire. Voir dire, voir dire, whatever. The hearing was public, and media representatives and the public did not need phones in the courtroom to lawfully report during breaks. Such reporting enjoys full First Amendment protection. Yeah, but you're not supposed to tell people what's going on in that court because it's secret. No evidence linked the defense team to any posting. Nevertheless, the accused attorney and officer of the court was humiliated and barred from returning. The episode publicly branded the defense as untrustworthy and disobedient despite the absence of any rule violation. Partial courtroom closure without constitutional justification. This ejection of defense attorney during the December 18, 2025 pre-trial hearing also functioned as a partial courtroom closure. The attorney was excluded from a public criminal proceeding for the remainder of the hearing without notice, without findings, and without identification of any interest that could justify exclusion. Partial closures, no less than full closures, implicate the Sixth Amendment right to a public trial and most must satisfy the framework set out in Walter v. Georgia from 1984, as adopted by the Arkansas courts, Mitchell v. State from 2019, and Spencer v. State from 2025. Like, you just had a lesson in this about open courtrooms, right to public trial, and yet you still forget. The court's own statements demonstrate that the exclusion was not based on disruption, safety, or witness intimidation, but on a belief that someone was reporting on the proceedings via social media. The rationale cannot support a courtroom closure. Once a hearing is open to the public, truthful reporting of what occurs inside the courtroom is constitutionally protected. Arkansas Democrat Gazette versus Zimmerman from 2000, citing Nebraska Press Association versus Stewart from 1976, the fact that a member of the public or press relays information about a public proceeding, whether orally or through social media, provides no lawful basis to exclude anyone from the courtroom. Shouldn't give a fuck what anybody's rights are. She's the god in her courtroom. Even where courts confront concerns far more serious than those asserted here, such as alleged threats or intimidation, a courtroom may not be closed without evidence in the record and specific findings justifying the restriction. No such evidence or findings were made. The court did not identify an overriding interest, did not conduct alternatives, and did not tailor the exclusion in any way. The court's only concern justifying closure of the courtroom was a constitutionally protected activity. The summary removal of the defense attorney from the courtroom therefore reflects the same disregard for the constitutional limits on courtroom closure that the Arkansas Supreme Court has already criticized in this case, describing a troubling pattern of attempts to shield this case from public view. Exactly. January 13th, 2026, order closing the courtroom. Same pattern continued with the court's January 13th, 2026 sua sponte order limiting courtroom occupancy and no recordings, which claims it is in service of the courtroom security, decorum, and orderly administration of justice. In reality, however, it's a functional courtroom closure that mirrors and escalates the secrecy concerns the Arkansas Supreme Court already condemned when it vacated the gag order. The court will allow only 20 members of the public during voir dire. The cap total of occupancy at 55 for the trial itself, including parties, counsels, staff, family members, observers, and media, and limited media to one representative per outlet with no overflow room, no video feed, and a hard head count that includes participants. The public is effectively locked out. That is a closure in everything but name. The Arkansas Supreme Court has already warned the court about closing the courtroom without constitutional findings. Vacating the gag order, the Supreme Court cautioned that any closure requires an evidentiary basis and adherence to the required constitutional analysis set out in Waller v. Georgia. The sitting of every court shall be public. The concurrence described a troubling pattern of attempts to shield this case from public view, from closed arraignment to sealing the case, suggesting that the order on the review before the Arkansas Supreme Court was not isolated problem, but rather indicative of star chamber-like atmosphere. The Supreme Court emphasized that the secrecy erodes public trust, and concurring justices urged reassignment. Under Waller, any courtroom closure, partial or full, requires a specific overriding interest likely to be prejudiced, a closure no broader than necessary, consideration of reasonable alternatives to a closure, and for adequate findings to support the closure. None of these prerequisites are present in the court's courtroom closure order, in direct conflict with Waller and the Arkansas Supreme Court's expressed guidance. There has been no disruption, disturbance, or security incident, no identification of overriding interest, no narrowing of scope, no alternatives considered, and no findings made. Like the vacated gag order, this restriction reflects a continuing disregard for constitutional framework that guarantees public access to criminal proceedings and Spencer's right to a public trial. Technically, restrictions and functional impairment of the defense. Separate from this effective closure of the courtroom, the court's January 13, 2026 order also imposes sweeping and unjustified technological restrictions that cripple the defense's ability to function at trial. In addition to capping attendance, the order bans all recording devices, including cell phones, Apple Watches, iPads, recorders, and eyeglasses. Like the Meta eyeglass, like recording glasses. As written, this prohibition extends to laptops, tablets, and phones used by counsel, even when not used to record. The court had previously informed defense counsel that the courthouse lacks any private workspace for the defense or defense witness. The combined effect of these directives is to isolate defense counsel from their own staff and informs information sources during the trial. There is no factual or legal justification for such a ban. The record reflects that nothing that would warrant treating attorneys as security risks. Attorneys are officers of the court and subject to professional discipline. Counsel already possesses the materials that will be presented at the trial and can obtain certified transcripts afterward, rendering the prohibition unnecessarily necessary and irrational. The order's practical consequences are severe. It prevents defense counsel from performing core trial functions, coordinating with staff and witnesses, accessing digital exhibits and notes, communicating in real time with assistants and researching evidentiary issues as they arise, attempting to print and duplicate every potential reference document in advance is both impractical and impossible given the complexity of the case, the volume of the discovery, much of it is digital, and the length of accumulated pleadings compromising the record. The burden is also asymmetrical. The state maintains offices in the same building within the steps of the courtroom. and thus retains full access to electronic resources and personnel. The defense, by contrast, is stripped of its tools under the threat of sanction. Such imbalance serves no legitimate purpose and only reinforces the appearance that the court distrusts and disadvantages to the defense. We aren't living in the Stone Ages anymore. Like, we need the computers. At least defense counsel does. By preemptively barring counsel from the technology necessary to perform their duties, the court has created a functional obstruction to the right to a fair trial. These technological restrictions, layered atop the effective closure of the courtroom, deepen the perception that the court's administration of this case departs from neutrality and transparency. Pattern of restricting public access and expression. The court's gag order, its management of public records, its conduct during pretrial hearings, and its most recent restrictions all reflect a continuing effort to shield the proceedings from public view. Those efforts bear directly on the public's ability to reevaluate the conduct of public officials and make its own assessment of the proceeding against Spencer. Public concern has been widespread over the treatment of both Fossler and Spencer by local officials. The Arkansas Supreme Court's decision vacating the gag order reaffirmed that public discourse and scrutiny of official conduct are protected, not prohibited. Transparency is therefore essential both to ensure Spencer's right to a fair trial and to maintain public confidence in the judicial process. Following that decision, however, the court's conduct has exhibited the hallmarks of retaliation prohibited by First Amendment. Spencer's successful petition for writ of certiorari was protected activity under the right to seek redress of grievances. The court's subsequent actions, including publicly reprimanding defense counsel, restricting courtroom access, imposing unprecedented limits on electronics, even for attorneys, and closing the courtroom to those who are suspected of reporting on the proceedings, constitute adverse actions that would deter a reasonable person from further exercising those rights. The temporal sequence and pattern of punitive orders strongly suggests that these measures were not neutral case management decisions, but a response to Spencer's exercise of protected First Amendment rights. Retaliating against a litigant for invoking appellate review is incompatible with impartial administration of justice. Despite the mandate for public trials from the Arkansas Supreme Court, the court has consistently acted to limit what the public may see or know, except when Spencer sought legitimate protection for his daughter. Protection that the court routinely afford in far less sensitive circumstances. The court's selective secrecy sends the opposite message, that Spencer is too dangerous for a public trial, that the public cannot be trusted to witness it, and those who speak about it may face sanction. The cumulative effect is to insulate the actions of both the state and the court from public scrutiny until well after the fact. The only fragmentary recollection remains that the secrecy fosters the appearance of bias and undermines respect for the judicial process itself. Moreover, because Spencer is declared a candidate for public office, the constitutional stakes are even higher. The public has a legitimate and heightened interest in transparent judicial proceedings involving a political figure. Structural conflicts and appearance of partiality in evidentiary rulings. Although this case will ultimately be decided by a jury, the role of a trial judge in shaping that process cannot be overstated. The presiding judge will rule on admissibility and scope of expert testimony, resolve motions in limine, address objections in real time, and determine whether witnesses, particularly law enforcement witnesses, are providing responsive and complete testimony. These rulings will directly affect how the jury understands the state's investigation and handling of the evidence, the credibility of the state's witnesses, and ultimately the strength and the merit of the prosecution's case. The court's demeanor and treatment of counsel also impact the jury's perception of counsel and its assessment of counsel's credibility. Imparting disdain or disregard unfairly jeopardizes counsel's ability to effectively advocate for the defendant. The court's responsibilities take on heightened significance here because substantial aspects of the defense will focus on investigative failures by local law enforcement, including the failure to secure and preserve critical evidence. The court will be required to rule on objections, evidentiary foundations, scope of cross examination, and relevance when those failures are explored before the jury. They're going to do some Bowden defense stuff. Inadequacies of an investigation are very important. The court will also be required to decide whether law enforcement witnesses may be impeached, whether omissions or investigative shortcuts may be characterized as such, and whether expert testimony may highlight gaps in the state's evidence and the credibility of law enforcement witnesses. Against the backdrop, the court's close professional relationship with local law enforcement create an appearance problem. Regardless of subjective intent, a reasonable member of the public would question whether a judge with long-standing institutional ties to very agencies whose conduct will be scrutinized can impartially adjudicate objections, evidentiary disputes, and credibility determinations arising from those failures. Your Honor's continued involvement risks undermine public confidence in fairness of the proceedings. Almost done. The concern is further magnified by Spencer's current status as a candidate for public office. Spencer is now a political actor and, by extension, a political adversary of a public official who is expected to be a witness in the case and whom the court has worked professionally for many years. Spencer has openly criticized that official. The court and the prosecution regarding the handling of this case and other matters of public concern. Those criticisms constitute protected political speech, but they nevertheless place the court in a position where its rulings may reasonably be perceived as entangled with institutionally loyal or political contexts. Spencer's candidacy did not rise in a vacuum. He decided to run for public office in significant part because of his experience with public officials in connection with the case, and his perception of those officials failed to protect children, failed to conduct a competent investigation, and then sought to hold him criminally responsible for consequences of those failures. Spencer has campaigned on those experiences, criticizing the conduct of public officials' handling of this case as emblematic of broader institutional problems warranting a public accountability. In these circumstances, the risk of undermining public confidence in the fairness of the proceedings includes the risk that unconscious influences arise from longstanding professional relationships, public criticism, and political context could affect or appear to affect judicial decision-making. Even conscientious judges are subject to unconscious influences arising from long-standing professional relationships, public criticisms, and the adversarial dynamics of electoral politics. Where a child judge is repeatedly called upon to rule on objections, evidentiary disputes, and witness credibility involving a political adversary and longtime professional associate under the unique circumstances presented here, a reasonable observer could question whether those rulings are or appear to be influenced by considerations outside the merits of the case. The concern is reinforced by procedural history due detailed above, the court has repeatedly acted in a way that limit public scrutiny and constrain the defense's ability to fully present its case, while the state has faced no comparable restrictions. When viewed alongside the court's role in earlier decisions that set the case in motion, these actions compound the appearance that the court is not positioned to preside as a neutral arbiter over disputes that directly implicate the court of law enforcement and public officials with whom she has close institutional ties. Under the governing standard, recusal is required where a judge's impartiality may be reasonably questioned. Here, the court will call upon and decide whether the jury hears the full extent of the investigative failures by law enforcement agencies with which she has close professional relationships, and where the defendant is simultaneously a political candidate, an outspoken critic of institutions involving reassignment is necessary to preserve both the reality and appearance to a fair trial. Conclusion. The responsibilities of the court must be carried out by a judge whose impartiality is beyond question. Any reasonable member of the public aware of the history of these proceedings and the chain of events that led to them would conclude that the court's impartiality might reasonably be questioned. For the reasons outlined herein, it is respectfully submitted that Your Honor should recuse from further participation in this matter to avoid the appearance of partiality, and that the case be reassigned to another judge for all future proceedings. Spencer additionally requests that the court seek the expedited appointment of judge to hear this matter so the trial may proceed without unnecessary delay. Spencer does not object to the court entering an order of recusal without a hearing. However, if the court declines to do so, Spencer requests that a hearing be held on this motion. And that is signed by Lassiter and Casanelli, Michael Kaiser, Aaron Casanelli, certificate of service, and all of that. So that is their motion to the judge to recuse herself. And they basically kind of lined up the same things in their writ to the Arkansas Supreme Court. And then, okay, let's then go to, no, that's not what I want. Okay, hold on. Okay, 4XA. All right. So we're not going to necessarily go through everything on this, but I will the thing is it's really hard to link the documents. So what I will do is I will write what they're called and things to look at. And but I will put a link for the case documents in the description box so that you can go to them. So these are at the bottom of the documents, case documents filed in January of 2026, January 16th. And so this one is called Exhibits to the defendant's motion for judicial recusal. And so we heard them cite to all those different exhibits, the emails, and everything, them saying that they didn't have Bossler's records, the pro hoc vice admission, public statements, the written request for certified copies of Fossler's court records, showing that they've been looking for this stuff for a long time. What is this one? Those are going all over his counts. And those were signed by Chuck Graham, prosecuting attorney. They asked, was there not a bond hearing? There would have been a first appearance after his arrest, and that is not placed on the record. And then his plea and arraignment was waived, so there was no appearance. And of course, his case is now closed. Okay, where's the proof of that shit? And it said, I've attached forced appearance form. And it says Judge Teresa Smith presided over his first appearance and set bond. So this is where they're saying, it was Judge Teresa Smith, not Judge Elmore, but still circuit court. So here is the pretrial order. $50,000 bond, which you only had to post $5,000 of. Circuit judge, all that. And I think, yeah, but there's no case number on it. The defendant shall have no contact, either directly or indirectly, in person, by telephone, mail, social media, or any other means, with somebody, or his or her immediate family or friends. They can't have firearms, drink, do drugs or any of that. They have to update with their address. That's it. And it says the 12th of July, or July 20th. 12 July 26. Okay, which makes no sense to me there either. So this stuff will be there if you want to go through it as well, but the Aaron Spencer's attorneys did very well in laying out basically what all this is. This is just the proof backing up all their assertions. So then we get to what in the world? Okay, that's okay. Let's go back over here. Judge's recusal, state's response. The state said that, is this what I wanted to look at? D1. Okay. So about the security measures, it is interesting because the state is like, individuals since late 2024, let's bring this up so you can see it. But since late 2024, apparently there has been a bunch of threats and horrible things being said, which people don't do. Do not contact the people in this case. Do not call the court. Do not call any of these people and threaten them or anything like that. You can tell them that you have a disdain for them, but do not break laws. But they said that they've had these things and they have been inundated with violent threats from individuals. They have expressed their desire or outright plan for those staff members, along with their children, to be raped, dismembered, or otherwise harmed. Which don't do this shit, people. I don't care how pissed off you are at a judge or any of this stuff. This is not how you conduct yourself. We don't act like this. This helps nobody. This makes it to where people are not going to have open court cases. And if we want to continue to have transparency and know about what is going on in the world out there, people online need to learn how to behave. And I'm not saying that it's anybody that watches myself, Defense Diaries, or anybody. Just don't do this. This is not helping Aaron Spencer. Aaron Spencer does not want you to do this on his behalf or anything like that. But it says, in December 2024, an individual called the prosecutor's attorney's office like 5 times, telling the office that he was going to kidnap their children and make them watch as he arped and murdered them. And those threats immediately were reported to law enforcement for investigation. Prosecuting attorney's website has received submissions encouraging prosecutor Chuck Graham to unalive. Also stating that I wish you the exact day this predator got and deserved. I hope that you all enjoy dying slow and painful deaths like you deserve. He should put a few holes in your head, and the world will be a better place when you're in hell. Okay. The world will be a bit. Say that. Don't contact them. And then, so that's at a bunch of different dates. And then there was on August 2nd, 2025, an individual left a message from Mr. Graham on the website submission form with the name Grape Judge Elmore and the contact email address listed as fuckyou@freeaaronspencer.com. This is just not okay. Okay? Not okay. I will come to Grape Barbara Elmore, her loved ones, her siblings, her children, and her co-workers. I will ARP her like her buddy Fossler ARPed Spencer's child. I will ARP you too. You smarmy effing fag. See how you feel about it. I will ARP your wife and kids and your loved ones. I will ARP, dismember, and burn your corpse. You PDF file. See you next Tuesdays. I hope you'll meet the fat grape in hell, you swine. This helps no one. Helps no one. Especially when it says at freeaaronspencer.com. That makes it look like something else that it's not. That is horrible. People are, like clown judge, things like that. Like, apparently there's a lot of these. These are horrible. And nobody should say this. They've been brought to the attention and, And all this court security staff is, because of that. And so that is the reason they're taking such heightened security presence and protection measures. Okay. So that's what they say, which is horrible. And I get. But okay. But the problem with some of this stuff, which is horrible, and the defense will agree that, yeah, we don't need any of that BS. And there are ways to make sure nobody's bringing in stuff of all that, is that Lonoke County office has observed outside the courthouse and parking lots, nearby streets, whether orchestrated or not, it added overwhelming presence. Until now, no one, not the court, not the state, has given Spencer or his counsel any information about threatening communications, much less discussed with them what security measures might be appropriate while not impairing Spencer's constitutional rights. And this information was only forthcoming after the defense counsel lodged a formal objection to excessive displays at pretrial hearings. The court's January 22nd, 2026 order denying recusal, and later the same day, the state's response in the defendant's motion to prohibit it prejudicial security measures at trial are the first time there has been any formal communication or court record of information regarding threats related to this case. And those are only references in pleadings. Although the deputy prosecuting attorney informally mentioned the day prior, the 21st, after defense filing on this point, on a call with the defense counsel, that his office had received hostile communications, counsel for the state and defense both acknowledged that unfortunate reality that this is not unusual for participants in the criminal justice system. Both counsel have experienced this many times before. Yeah. The state's response contains assertions but provides no evidence regarding these threats that might support findings pertaining to security risks, and does not provide details that might provide insight as to the realistic security needs. Numerous of the quoted threats to Chuck Graham, as written in the pleading, do not appear to relate directly to this case, or could relate to numerous cases the prosecutor's office is pursuing. As of the filing of this reply, the defense still has not been provided anything tangible related to these purported threats. So you're like, yeah, we need this because of all this. And the defense is like, well, why the hell have you not told us that this shit was happening? And y'all are just now saying this now that we're like, y'all are not being fair and unbiased with these security measures. And now y'all are like, well, everybody's threatening us and telling us that this should happen to us. And so confirm that counsel for the state and court are aware of communication directed at the other. It seems apparent that these communications have been the subject of prior discussions between the state and the court, without any mention of, much less inclusion of, Spencer's counsel in these discussions. These are case-related discussions that resulted in court's actions in the case that negatively impacts Spencer, yet his counsel have been excluded from any discussion or notice concerning the communications or security measures. So are there ex parte communications happening, which is not okay either? Spencer and his counsel would agree to reasonable security measures for the protection of all participants. However, the court's decision to employ an alarming excessive law enforcement presence at the pretrial hearing without discussing the need and impacts of doing so with counsel for the state and counsel for defendant is troubling. Spencer is entitled to the opportunity to address the impacts of the heightened security. It's also concerning that the court felt that there was a reason to engage in such a display of force without notifying the defense, suggesting and giving the appearance that perhaps the court has allowed these communications to influence perception of the defendant. Yeah, the defendant did not say, "Hey, everybody, go do this." Aaron Spencer did not put his rubber stamp of approval on this stuff. Once again, they're just like, well, these are your people. So, all right. Now, and of course the state, does not, they're like, she does not need to be recused. Okay. So here is the judge's response to this recusal. Okay. So January 22nd, Judge Elmore wrote this response to motion for judicial recusal. On this day, the court responds to defense counsel's motion for judicial recusal. Many judges set bond and see defendants at first appearance in the 23rd District. The judge appreciates the work of all other judges that assist her with setting bonds and doing first appearances. This judge never saw the deceased Michael Fossler. Also, this judge did not set the bond of the deceased. Due to discovery in this matter, defense counsel is well of these facts. Well, they said the circuit court. And maybe you're covering for the circuit court. Also, defense counsel is well aware that this judge did not sign the affidavit of probable cause or warrant of arrest for the defendant, Aaron Spencer. Okay. In November of 2024, the court saw the defendant so that he might plea, set pretrial and jury trial dates. The courtroom was not closed. Defense counsel may or may not remember the defendant, all counsel, and defendant's wife were allowed in the courtroom. This is an extremely small courtroom. Moreover, other defendants with their loved ones and bondspersons were in the courtroom. There were issues with very limited space. Very is bolded. Courtroom management and security. Also, at the time, there were a number of instances of blue. Therefore, overcrowding was an issue. There has been no favoritism to one party or the other in this matter. Defense counsel, with the last couple of months, tried to enter motions under seal. The court would not allow said motions to be filed under seal. The public, media, and prosecution all have the same right to see these documents. Said documents have never been filed. Because you didn't care about protecting a child victim, according to the defense. The judge is going to do her duty as a presiding judge over all criminal cases to give the defendant and the state of Arkansas a fair trial in this matter. The state doesn't have a right to a fair trial. The defendant does. The court previously entered an order limiting the number of media representatives and members of the public permitted inside the courtroom during future proceedings. This courtroom does not have unlimited seating, although it is the largest courtroom in the courthouse. After accommodating approximately 100 potential jurors, along with family members of parties, counsel, or record, the counsel, staff, and remaining space is limited. As a result, approximately 20 Additional individuals, including members of the media and public, may be permitted to enter the courtroom, and such individuals may be required to stand at the rear of the courtroom as the trial proceeds and jurors are excused or seating becomes available. Additionally, members of the media and public will be permitted entry. These limitations are imposed solely due to the space and security constraints and do not constitute a closure of proceedings. Not only is the space an issue in the proceedings, so are management of the courtroom and security are issues. There have been many threats against the court and others involved in the trial process. Also, due to fire hazards, the courtroom should not be packed with individuals standing or sitting in areas that block the doorway. Nobody said you needed to make fire hazards. Nobody said that shit. This case should proceed as scheduled, and this judge intends to hear this matter. Therefore, the judge does not recuse in this matter. It is so ordered. Barbara Elmore, Circuit Judge. So that is what Judge Elmore said. So, all right. So she doesn't recuse herself. So they're like, all right, well, we're going to take this to the Arkansas Supreme Court. And by doing that, which is crazy how fast they got this done. Because they filed that, like I said, the trial is set to start jury selection on the 26th. And they put this in right towards the end. And as soon as the defense, did the writ for Arkansas Supreme Court, they were like, great, state, give me your response. Then they listened to it. And so the state responded basically, backing up what the judge is, because they are all about that. Let's see. Yeah, they ordered him to respond. And then they made a ruling. And I don't know if there was oral arguments or if they just ruled on the papers. I'm guessing it was just ruled on the papers. All right. Joint motion by the state and defense to briefly continue the trial date to the storm of the century. Court is happening this morning. It was kept. So I think jury selection was going to start on Thursday, the 29th, with trial starting on February 2nd. And then where is this order? Is it on the state's website? Docket entries. Where is... me see. Maybe this is it. Okay. Okay, here we go. My bad. All right, we're going to bring this up. Sorry, I was not prepared. All right, and then here is what the Supreme Court said. Formal order. State of Arkansas, Supreme Court. Be it remembered that a session of the Supreme Court begun and held on January 23rd, 2026 was the following proceeding to wit. In Aaron Spencer from appeal from Lonoke County Court, Circuit Court, State of Arkansas. Respondent petitioner's petition of writ of certiorari or centaurii and other relief, emergency consideration requested, expedited consideration granted, petition of writ granted, writ issued, Circuit Court's January 13, 2026 order limiting courtroom occupancy and no recordings vacated. 23rd Judicial Court Judge Division 1, Honorable Judge Elmore removed from the case to be reassigned to a special circuit judge appointed by this court. Baker, CJ, and Hudson, and Wood, or CJ Baker and Hudson and Wood, JJ Wood deny the petition for writ. Okay, but it was majority. Is immediately stayed pending this court's appointment of special judge. So, not only are they saying that the limiting courtroom occupancy and the no recordings order is vacated, the judge is to be removed off of this case, and that a special judge is going to be appointed by the Arkansas Supreme Court. So it's not going to just be that another judge from the same circuit court or will be put in there. They don't get to appoint someone. The circuit or the Supreme Court is going to choose the judge that sits on this case because they cannot even trust them to pick a judge correctly. So they are going to choose them. And it can be from anywhere in Arkansas that this judge can come from. And is immediately stayed pending this court's appointment of a special judge. So the defense won their argument. The judge is recused. Now, we don't know if that means that there is going to be cameras allowed in the courtroom. Okay. And then Defense Diaries posted something else too. So I don't know if for sure now that I don't know if for sure now that it is going to start on the 29th either. It might still, but I don't know. But they usually are pretty quickly. If you watched the YSL, trial. Um, but they removed a judge mid-trial or many, many, many months into the trial and had some other judge come in like a day or two later and go through it then. And so that judge was not like, there's no way she could have caught up on so many months and years of all this stuff, but she had to come in and make the rulings on the trial. And so it happens. So everything may just stay on track. And then they just get a judge in here that doesn't really have the time to learn everything about the case that like Judge Elmore would know. But at least we're going to have, a fairer trial for Aaron Spencer, hopefully, out of this. And then I saw somewhere as well that I feel like maybe it was on Free Aaron Spencer's thing. Dang it. I thought it said that she was going to retire. Maybe that was somebody else, because there was a bunch of people retiring. But anyways, if she is or if she's not, good riddance to her. And justice for Aaron Spencer. I will also have his defense fund in the description box as well. Thank you for watching this video. I know it was long, but very important, especially with this case starting. But let me know your thoughts and opinions down below, and I will see you in the next one. Bye.